Yes, hello and welcome to Legal Talk. Today we are discussing something very, very interesting. It's something that a listener sent in who remains anonymous. And she wrote, I work as a freelance graphic designer. I designed a logo for a company. They didn't use it, but they hired another designer and then he or she copied my design and made some adjustments and then passed it off as his or her own. The company is now using this amended logo commercially. Can I sue? That was the question that was sent in. And today we chat to Vanessa Lawrance from Hahn Attorneys, who's going to give us some answers, which will hopefully shed some light into the matter. Vanessa, welcome to Legal Talk.
Thank you very much. Nice being with you.
And nice being with you. Vanessa, is there a short answer to this listener's question?
Unfortunately not. We have to look at a whole lot of different stuff. I'd need more information to be able to say one way or the other.
Okay, but who actually owns the rights in the logo?
So in terms of the Copyright Act, there are various types of works. This work, the logo, will be an artistic work. Some of the others are musical works or that type of thing. But this particular one we're talking about is an artistic work. In terms of the Act, where skill and effort is used in the creation of a work, copyright vests in the creator of that work. So in other words, the graphic designer, the person that asked you the question, she will be the owner of the copyright in that logo.
Okay, so assuming the company paid the graphic designer for the logo, didn't they actually buy the ownership?
No, not necessarily. Ownership of copyright can only be assigned in writing. In other words, there has to be an agreement between the parties that specifically identifies the copyright work. So a judge must be able to read that agreement. And from the agreement, from the face of the agreement, without any other parties giving any testimony, must be able to identify the item of copyright work. So there has to be an agreement, and it has to specifically say that the rights of ownership in this work that is identified goes from the initial creator to the new owner. Usually when one buys or when one pays a designer to create a work, you don't do that logo because you're assuming, that agreement, because you're assuming that the ownership goes across when you pay them. But that is not the case. What you're buying is the right to use. In other words, the ownership of the logo remains with the designer, and all that the designer sells in effect to the person who pays them is the right to use. That designer can even limit the way that they can use it. So in other words, they could limit that it can only be on letterheads, for example, or it can only be on the front window or whatever. That designer can still limit the way or the number of uses that the logo can be used for. So they can only print, say, 1,000 letterheads, and then they have to pay them again. So because this is not often known, people don't really realize what they're paying for.
Wow, that's very, very interesting. Vanessa, can the designer then prevent use of his or her logo by the company that actually instructed him or her to create that logo?
In theory, yes, because they still own the logo. They own the rights in the logo. So they could say to the company, no, I'm the owner. You may no longer use this logo. Unfortunately, practically, if it gets out in the public that you as a designer are going about having people pay you for what they think is ownership of the logo, and then later on coming across and saying, no, you're not allowed to use it anymore because I'm still the owner, that may be a little bit of suicide to the career. So in theory, yes. Practically, probably you don't want to be doing that.
Okay. And what about the other designer that actually copied the logo and then made some amendments?
Okay, so when you own copyright in an artistic work, you have the right to prevent unauthorized reproduction of that work in any manner or form, including making an adaptation of the work. Copyright also exists for 50 years after the creation of the work. It comes into existence automatically. You don't have to register it. So you have the right to prevent that reproduction or adaptation. And then you're going to ask me how big a change there must be for it to be a new work, or whether it can still be considered an adaptation or amended version of the initial work. I know there's a lot of stories out there that say it has to be 50% different or 80% difference. That's not what the Act says. The Act says that when you can identify the new work, I call it new in inverted commas, the amended work, when you can identify the original work in the new work, then it is a copy. So we always use the example out of one of Shakespeare's very well-known plays, Out, Out, Damn Spot. Everyone knows, if I say Out, Out, Damn Spot, everyone knows that that's Macbeth. And that's only a tiny percentage of the whole play. So if you can identify the original work out of the in inverted commas new work, then the inverted commas new work is considered an adaptation or a copy of the original work. When assessing that, they take into consideration, that courts will take into consideration objective and subjective similarity. So objective, you put the two works together and you compare them. It is possible that two people can create a very similar work completely independently from each other. So, for example, if you were to paint Table Mountain from Bloberg Beach, lots of people do that, then it's going to look very similar. And it's not that I copied someone else's work. I looked at Table Mountain. It's going to look very similar to me or to anyone else. So there could be an objective similarity, but still not considered sufficiently similar to be considered an adaptation or a copy. Then you have to look at subjective similarity. So the question in this case, this logo, depending on how simple the logo is, the new person could possibly have created something very similar without having view of the initial logo. But it depends obviously on the instruction that they were given. But if the company had the initial logo, the original logo, and then gave it to, and they had the opportunity to give it to the new designer, then obviously there's a subjective part to that too. They had the original logo. So the possibility is great that they gave it to the new person if the new person's logo is very similar to the original one. So then the subjective considerations come into account as well.
Very good explanation there. Just moving on to the next question, what can the original designer do?
Okay, so as a first step, we always recommend that you send a letter of demand. The reason being is the courts frown upon you just jumping off and trying to get money out of the other person without trying to settle it out of court. They feel they're overworked and they don't have enough time to deal with things like this. So we always send a letter of demand first, and in the letter you'll show your logo, their logo, and you say there's a copy, please stop copying immediately, stop use, etc., etc. If that can't lead to settlement, then the owner of the rights in the logo will have to address it at the High Court. They can first ask the High Court for an order compelling anyone to stop using that logo that they created, the initial logo. They can also claim damages, as in damages suffered because their logo was copied. Damages are virtually impossible to accurately predict. So what the Copyright Act has done, and at the time that it was done, which was 1978, it was very new and innovative. They said that you can, instead of a damages claim, you can also claim a reasonable royalty. Reasonable royalty is what you would have charged to a person for using your copyright work. So that's also allowed, and that's obviously much easier to prove. So you can go to the courts, you can ask for an order stopping them and an order for a reasonable royalty. And then obviously if you're successful, then you get an order for costs generally too.
Okay, and would the original designers sue the designer that copied his work?
You can certainly sue them, but your decision is always, as in law always, who is in the position to pay you more. So if the company has we call it deeper pockets, has more money, then you rather go for the company. If you feel that the designer has deeper pockets, then you can go for the designer. Nothing stops you from going for both. But obviously you're wanting you don't want to go to court and then find against a designer and then find it's a poor person that actually can't pay your fees at the end of it. So you would always make sure that whoever you're going for has enough money to satisfy your claim.
Vanessa, this has been very, very interesting and insightful. Big thank you for talking to us today and also answering that question. Much appreciated.
My pleasure. Hope it was helpful.
It sure was. Thank you so much. Vanessa Lawrance from Hahn and Hahn Attorneys on Legal Talk today.
Are you or your business in trouble and struggling to find a solution? Call Hahn and Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn and Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn and Hahn Attorneys, Wednesday mornings at 10 on eRadio.